Welcome back to this week's edition of Freedom and Prosperity Radio. And no bigger story, I think, hit the wires over the past week than the Texas petition first, as we had here last week, covered for you the concept behind the petition. Then, obviously, the Supreme Court's declination to hear the case, the question over how that came about, that 5-4 vote. To help us make sense of it all, for the Federalist.com, where you read her stuff, Margot Cleveland is on the program with us. Margot, welcome to Freedom and Prosperity Radio. How are you doing this weekend?
I'm doing well. Thanks so much.
So it seemed at first blush that this was at very least something that was indisputably going to be heard, though there was always that opportunity that the Supreme Court could turn down the case. So even with that door open, I don't want to circle right to the ending first, but what was behind the Supreme Court deciding that they wanted to say that Texas had no standing? That seemed to be more than they needed to say in declining to hear the case of Texas versus Georgia, Wisconsin, Pennsylvania, and Michigan.
Well, actually, I think that that's all they said, and they needed to say a lot more. So for your listeners, standing is actually a constitutional requirement. So one of the nice things about everything going on in 2020 is it's reminding people that we have a constitutional government and that the Founding Fathers set rules on how you do things. And Article 3 that governs the judicial branch says that you must have a case or controversy. And when the Supreme Court, and it was a 9-0 decision in that there would have been no relief to Texas. And in a short order, 7 of the justices said that there was no standing. The issue here that I have with the decision is we don't know why, because they didn't say. They just said there was no judicially cognizable interest that Texas had. And they said, and therefore there is no Article 3 standing. There was this no case or controversy between Texas and the defendants, the putative defendants, the defendants that they wanted to sue. Mm-hmm. So the court did not give Texas the permission to file the lawsuit. And that's something else that's kind of a unique procedural little, question here that people need to understand is, when one state is trying to sue another state or multiple states, Texas was suing Pennsylvania, Wisconsin, Michigan, and Georgia, the only court that actually has the power to resolve that is the Supreme Court. And strangely, the Supreme Court has also said, but we don't have to take the case. So that's what they did in this short 2-sentence order, said that we're not taking this case, we're denying them permission to file because they lack standing. The thing to keep in mind, though, is even if they had said, okay, you can file it, that rationale that there's no standing would have led the court to immediately toss the case.
Right.
And said no standing. But that's where I have the problem. You say, well, do they really need to get to standing? That was all they could do if they didn't want to give us more of an explanation. And the problem I have is that explanation tells us nothing. It doesn't tell us why they thought there was no standing. And I see a pretty big issue here. I'm not saying Texas wins. I'm not saying that this is definitely how the Constitution reads. But there's a pretty serious complaint that Texas has under the Electors Clause of the Constitution. And for your listeners, in the Constitution, one of the things it does is it tells us how the president is the president. How does the president become the president? And each state will name electors. And this is something Founding Fathers were, kind of stewing over of how to do this.
Very controversial, too. I mean,
right.
Patrick Henry and George Mason and James Monroe were going to actually torpedo the Constitution over this.
So, right, there's a lot of history. And this is not something that I delved into a lot, but I've read all of the briefs that were filed. And it sounds that this was something very specifically considered. And it's key that they chose electors, not a direct election of the president.
Mm-hmm.
And specifically that the state legislative body would determine how those electors would be named.
Mm-hmm.
And in some of the past Supreme Court precedents, they went through and explained how at the founding, most of the state legislative branches were doing this directly. They were voting on it.
Right.
And then through time, it became based on a popular vote in the state. But the problem that Texas has is that they entered into a compact in the Constitution that we, Texas, agree to abide by these rules, and that's why we joined the Union. And you, other states, agreed to abide by these rules. And now you aren't, because the agreement was that you would do what the legislative branch said to do for the election. And those 4 states did not follow what the legislative branch had established as how to name the electors. And this came right from a concurrence in Bush v. Gore, where Justice Rehnquist went through and explained the significance of the electors clause.
Mm-hmm.
And it wasn't a majority opinion, but if you read that, you read the Constitution, you read the history, Texas has an amazingly crafted argument. And the Supreme Court, by not taking the case or not explaining the standing, has left half of Americans of the view that the Supreme Court doesn't care about the Constitution. And as I mentioned, I don't know what the right answer is. Maybe the answer is Rehnquist was wrong and that this is not a violation of the Electors Clause. Maybe the answer is that this is a violation of the compact that Texas had when it, joined the Union, but courts can't give a remedy for it. I don't know what the answer is because the Supreme Court hasn't told us. But I can tell you that a lot of people are looking at this as Supreme Court is ignoring the Constitution. They don't care what it is. I want to know what the answer is. These people are much smarter than I am. They have the broader historical perspective. There are so many different precedents that go into the answering this question that we need to know this because there were violations of what the legislative branch had said to do in those 4 states.
Well, Margot, and maybe we're approaching that the same statement a different way by adding the point that they declined to take the case because they didn't see where Texas had standing. They could have just ended the sentence that we declined to hear the case. They didn't. They were not obliged to say, as I understand it, why they didn't take the case. They could just say we were busy or we have a golf tee time or whatever, the reason may be. But by adding that statement, that last part, that's what opens that can of worms that you're talking about, because now you're saying, well, hold it. That almost sounds like precedential. By saying this, you're almost laying out the groundwork that no state would ever have that kind of position because they didn't go into detail as to where the standing was through any sort of hearing.
Well, a couple things here. I think that if they had just said we declined to take the case, period, that would have been even more offensive because we would have no reason to know why. And if you're going to exercise your discretion, I want to have some basis for it.
Oh, I agree.
And then just the second point on the standing is that there's very clear precedent that when a court declines to take the case, that's not considered precedential. So it's kind of, that seems like a very minor point, but you can't cite that and say the Supreme Court has held no standing because it came in the refusal to take a case. Although, I think that you're going to see some persuasive reasoning that other people are going to point to that and say it, or lower courts are going to point to that and say this is definitive. But again, how is it definitive? Because they didn't tell us why there was no standing. And also another point, and I made this in the article I wrote on it, is they were very careful with their wording. They said that there was no standing, and they said there was no cognizable harm for one state to complain about how another state runs its election. I absolutely agree with that. But that's not what Texas was arguing. They were arguing that the other states violated the equal protection, the due process, and the electors clause. And I also think that the Supreme Court, by giving its a couple sentences, it was giving as much as it could to keep everybody on board.
Mm-hmm.
I think if they had gone further, you would have had problems because you would have had those 7 justices disagreeing on why there was no standing.
Right.
And they wanted to have as close to a unanimous decision to prevent, kind of this internal civil war we're having about the election.
Right.
But it didn't work because we're very informed populace, and we know what the Constitution says. And I have not seen a legitimate argument for why that's not a violation of the electors clause. And that's really all I want to see. I might be wrong on why it's a violation. Maybe Rehnquist was wrong. But nobody has given us that. And I want the Supreme Court to do it.
Margot Cleveland is on with us, Federalist, great piece, 6 things to know about Texas's Supreme Court petition over 2020's messed up election. And you have a flair for understatement by calling it messed up. Margot, you mentioned, though, the standing and the constitutional premise that the citizens of these 4 states, and maybe that's where the standing had to come from, was from citizens of these 4 states maybe had to sue to the Supreme Court saying that they had their franchise violated by the fact that these governments inappropriately changed election laws. And we talked to Chris Kobach as the story came of the petition. He sort of was acting as the mouthpiece of it, along with A.G. Paxton. And he said very clearly that that these states did not go through the legislative process to change these election rules as laid out in the Constitution. They didn't convene the legislature. The excuse, as I've seen it given by at least 2 of the states, is COVID. And nothing more than that is. But Virginia, for all of our problems, we did manage to convene a special session of the General Assembly. So many of the things that we did here that these other states did, we at least passed it through our legislation process. So our citizens may not be happy with it, but it was legislated.
Right. And I think that you're right that there is a concern that maybe it wasn't Texas who should have been doing this. And a couple things I want to point out to the listeners is these decisions, the decision on the Texas case does not resolve whether or not there's elector clause violation that other people, whether it is state citizens, state legislators, state electors have. So they might have standing, or President Trump, for instance. Obviously, Bush v. Gore, there was standing to challenge the equal protection violation. So we might get some understanding under the electors clause from those other cases. But I still think that there's a problem when you say that Texas does not have an injury when other states ignore the constitutional requirements, given that there's this compact when you enter into when you join the union. And there was a amicus brief that did an amazing job highlighting this. It was filed by Citizens United. And they actually did a little bit better job than Texas in making the point. Texas was focused on showing, this concrete harm through who the vice president is. So they were saying Texas as a state is harmed because we care who the vice president is. They have a vote in the Senate if there's a tie, and the Senate represents the state. They were making the argument this is a structural problem, that this ignoring the legislative body harms the state based on the structure of the Constitution. Absolutely right. But I also think that we need to keep in mind that the harm was greater than just who the vice president was. a harm to our country as the way our Constitution was designed. But your point is valid, and it's very solid that there are other people who can still be presenting these arguments and are still presenting these arguments.
Margot, I want to ask, we only have a few minutes left, about 5 or 6 minutes left, but I want to poke into this because I raised this question to some controversy. Could they have been doing all of us a favor by not taking this case because of the nature of the court? It's very reasonable to think that they might have decided COVID was a valid reason to violate the Constitution, which opens a Pandora's box of what other emergencies can be declared to just ignore whole sections of the U.S. Constitution, and deciding not to want to open that particular box of nuclear material.
Yeah, I'd be hesitant to go there because I think that the Supreme Court, if it was COVID, wouldn't care. I think the hesitancy came from that it's a presidential election and they do not want to be perceived as giving the election to Trump. And I would say that is more of an issue than the COVID. I think that if COVID was the only question, they would have no qualms in taking the case. I think it comes down to a prudential view of we don't want to get into this and look like we're deciding the election. But you know what? It's your job to say what the Constitution means. And it might be what they thought was we have a better mechanism of doing it when it is a citizen of a state presenting it or President Trump presenting it than when it's Texas presenting it. And we'll have to wait and see what happens on that. If they actually resolve what I consider a tough constitutional issue. And I wish that more people would take that serious because you're getting kind of the off-the-cuff, these are ridiculous claims. And it's not a ridiculous claim to say the Constitution says the state legislative body needs to look at or decide how electors are appointed.
Well, and at the end of the day, I also know that in the previous 6 to 8 months, we've been approached by the dissolve the Electoral College anyway, and I worry that some of this is going to lay the groundwork for another round of this is Al Gore just was on TV 2 days ago talking about, this is proof we need to get rid of the Electoral College. So I worry that these sorts of landmarks that we have to get past, to avoid being just a direct democracy with all the warts of a direct democracy could be torn down under these, quote, crises.
Right. And I'm hopeful that as much as the liberal talking heads are pushing to get rid of the Electoral College, that you will have the populace as a whole recognizing the wisdom of it. And in some ways, this kind of shows you the wisdom of it, that if there are major problems, that the state legislative body can step in and try to fix it if there's a problem. And I think that something else that's being missed here is that no one is asking the state legislative body to declare Trump the winner. They're asking them to use their constitutional authority to decide what to do with the electoral votes. And that's what Texas was asking in the lawsuit as well. You get rid of the Electoral College, that option is going to be gone.
True. And that doesn't even scratch the surface of confidence in voting and the ability to oversee and to keep heard on it. Margot Cleveland is a professor, a lawyer. She's writing for The Federalist as well as Town Hall and many other places. You can follow her on Twitter as well at Prof. MJ Cleveland. And thank you again so much for your visit, your insight on this. And again, the article is 6 things about the Texas Supreme Court petition over 2020's messed up election. Please, get it at thefederalist.com. Share it with lots of folks. Put it in their Christmas cards. Who are we to judge? Margot, thank you so much, and I hope you have a blessed Christmas next week.
Great. Thank you. You as well. Take care.
And from all of us here at the Virginia Institute for Public Policy, let me re-echo that from all of us, our family to yours, and all of the work we do and all of our associates have the very merriest of what remains of the holiday season. We will be back here the weekend after Christmas and with a new program for you. So until then, for the Virginia Institute for Public Policy, my name is Joe Thomas. So long, and thanks for all the fish.